This is Debt Free in 30, where every week we take 30 minutes and talk to industry experts about debt, money, and personal finance. Here's your host, Doug Hoyes.
Over the last 3 months, there were many significant changes to the law in Ontario, and so today we're going to discuss both of them. To help me through it, I've got my partner and Hoyes Michaelis co-founder Ted Michaelis here. Ted, how are you doing today?
Fine, Doug. Thanks for having me.
So, issue number one, on December 1st, there were changes made to the Execution Act of Ontario. Why should anyone care? What's the Execution Act? What's it all about? What's the story there?
Well, so the most important thing about the Execution Act is that it sets limits, or rather protections, for individuals when they've been either sued or I guess when they file bankruptcy. It's the same sort of thing. So the Execution Act says these are the things that cannot be taken away from you. They're the basic minimum, I guess, needs for living, if you want to take it that way, that every person's entitled to keep, regardless of who they owe money to or what they owe money for.
So we're not just talking about bankruptcy. We are talking about, someone who isn't bankrupt may still fall under the purview of the Execution Act if they were to get sued, for example.
Yeah, I mean, the most common application of the Execution Act is somebody owes another person a debt. They are sued, so the person doing the suing receives a judgment against the individual that they sued. The court then issues a writ of seizure or a writ of execution, and that allows the person who did the suing to try and freeze a bank account or clean a bank account out, seize somebody's car, I suppose. I mean, if there was no Execution Act, there were no protections, then that piece of paper from the court would let you basically go to somebody's house and clean it out.
So Joe owes me money. I take him to court. I get a judgment against him, which is just a piece of paper signed by the judge that says Joe owes me $10,000, and I see that Joe has a $1,000 car in his driveway, an old beater. If there was no Execution Act, then theoretically I could just go take it.
That's exactly right.
So the Execution Act then, if it's a $1,000 car, I'm not going to be able to take it. If it's $1 million, brand new Tesla or something, if there is such a thing as $1 million car, then I assume I'm not able to take it. So obviously the Execution Act sets limits.
Exactly. It provides people with protection under the law.
So let's talk about changes then. So let's start with the example you just gave, a car or a motor vehicle, as they call it. So first of all, the Act says motor vehicle, which is more than just a car, I guess.
Yeah, it could be a car, it could be a truck, it could be a motorcycle. It can't be something like a trailer. It can't be something like, I don't believe it can be something like a jet ski. I think it's got to be a motor vehicle for the purposes of transportation on public highways.
So a motor vehicle obviously has to have a motor. That's why a trailer doesn't count. So if I've got
or a bicycle for that matter,
doesn't have a motor. So if I have a truck with a trailer, well, the trailer doesn't fall under this because it doesn't have a motor. So under the old rules, the exemption limit was $5,650. What's the new limit?
$6,600 even.
Okay, so what does that mean?
So it means that an individual is entitled to keep a motor vehicle worth up to $6,600. Now that's actually a bit of a misdirection too. They're allowed to have value in the vehicle worth up to $6,600. And I'll tell you what the distinction is. So if I've got a $2,500 beater, that's worth less than $6,600. Obviously, I get to keep it. It's protected under the law. Let's say I've got a $20,000 car, and I've got a loan outstanding against it. So if the loan is for $15,000, effectively, I've got $5,000 worth of value in that car. Well, $5,000 is still less than the $6,600, so I get to keep it. It's protected under the law.
So the loan is an important distinction then. So it's not the value of the car that matters, it's the equity in the car that matters.
That's right. It's the amount of your ownership interest. How much of that car do you actually own?
So, which means if I sold the car, how much would I get? So if I have a $15,000 car with a $10,000 bank loan, I could sell the car, but I'd first have to pay off the $10,000 bank loan. I'd end up with $5,000. Therefore, it's exempt.
That's right. Now, the law is a little funny. It says that the car could be seized. So a creditor could come along and take the car, but then they're required to first pay out any other registered liens. So the loan would get paid first, and then the up to $6,600 would be paid to the fellow who had the car. And so why would a creditor go and take a car that had less than $6,600 worth of value in it? Because they'd get nothing for doing all that work.
Which is why in real life we never see that. That's not something that happens.
That's what, particularly in bankruptcies now. Cars are almost never seized from people because they're either driving something of lower than $6,600 value, or they've got a loan outstanding on it and they want to keep the car, so they keep making their loan payments.
Yeah, it would be very unusual for someone with a brand new $30,000 car to be going bankrupt, because if they had $30,000 to buy the car, then presumably they wouldn't be in that same financial situation.
That's right.
So someone goes bankrupt then. How do you know what the car's worth?
Well, so we start by the individual's got to tell us what it's worth. And so they'll get probably something called a fair market letter. A used car dealer or someone will tell them what they think they would give them to take that car off their hands. We'll then cross-check that to things like the Black Book, which tells you the wholesale value of a car, to see if it's reasonable. At the end of the day, the only way you really know what something is worth is by actually selling it. But frankly, if there's any doubt, the bias goes towards the individual who has the car. Because if a trustee ever seizes and sells something, we always get less than what they think it's worth, because it's a trustee selling it and people are looking to get a deal.
Yeah, and we're selling it at an auction or something like that. We're not getting full value. And in most cases, there's not a whole lot of judgment involved. If you're driving a 20-year-old car with 200,000 clicks on it, it's unlikely that it's worth more than a couple of grand.
Right.
And so it's only if it's right around the limit that it would matter. So
there is one way that people get caught. This exemption applies to a single vehicle. So somebody that's got two vehicles registered in their name, maybe I've got a pickup truck that's worth $2,500 and I've got a motorcycle that's worth $1,500, I can only apply the exemption to one vehicle. So I apply it to the pickup truck. The motorcycle is still at risk because that's a second vehicle.
So one motor vehicle is what applies. So I could have two old cars worth $2,000 each. Only one of them is exempt under this legislation.
Yep.
Okay. So if anyone's listening and they have a car, then the thought process is, what's it worth? So check the Black Book, get an appraisal, ask the car dealer what they'd give you for it if you returned it. If it's worth less than $6,600, there's no issue. If there's a loan against it, well, what's the payout on the loan? You deduct that from what the value of the vehicle is. If that's less than $6,600 in a bankruptcy, we're not going to take it.
Right, and it's almost always less than zero when you do the math you were just talking about.
Yeah, it's I can't remember too many cases where someone has a loan or a lease agreement that leaves a whole lot of equity at the end. So okay, so that's cars. Now, there's other things mentioned in the Execution Act. One of them that I find interesting is clothing. So under the rules as they existed before December 1st, 2015, necessary and ordinary apparel was exempt up to $5,650. Under the new rules, there's no limit. But the rules say necessary clothing.
Right.
So what's the difference? Tell me about that.
Well, the problem we're having with this is that the necessary clothing hasn't been defined anywhere. So under the old regimen, we assumed things like jewelry, athletic equipment, things that you could put on your person could be broadly spoken included in that exemption. Now, saying necessary clothing, I don't think you could justifiably say somebody's jewelry is necessary clothing. I don't think you could say that somebody's hockey equipment is necessary clothing.
Yeah, the word is clothing. So, what is clothing? Well, I guess we'd have to get the lawyers involved to figure it out. And the reason we don't know the answer to this is because it's never gone to court to be figured out.
It's too new a law. I mean, the change was made December 1st, 2015.
Well, and even the word clothing, which has existed in I guess the word was apparel before, but even though that word has existed, it's unlikely that anyone is going to have enough clothing that it's worth it for some creditor to go to court and spend a whole bunch of money on lawyers to figure this out.
That's right.
So our interpretation of the rules, and again, I want to stress that this is our interpretation. It's a new rule, like you said, and it has not been tested in court. So someone could go to court and the judge could say something different than what we think. But our interpretation of it is, if it's clothing and if it's necessary clothing, well, then you don't have to worry about it. It doesn't matter how much it's worth.
That's right.
If it's apparel, then too bad, you're out of luck. So that's something you're going to definitely want to discuss with us. Now, I don't think your old hockey equipment is something we're going to ever take anyways.
Seems unlikely.
Because we don't want it, but it is an issue that needs to be raised. Now, I guess the logical question then would have to do with jewelry then. So is there a place where jewelry comes under the Execution Act?
Yeah, I'm of the opinion that it isn't protected anymore. I mean, at one point there was a general exemption for personal possessions. That's been out of the law for quite a long time, but people have been still using the concept. So you could simply say, these are my personal items that I want to protect, and things like a wedding band would fall under that. I don't think there's any place in the Act now where a wedding band would fall.
No, and I agree with you. And in fact, I sent a letter to the Attorney General for Ontario, who is the person who is responsible for laws. And she did write me back a perfectly nice letter saying, she
doesn't know either.
I don't know. And you can go to our website at hoys.com and do a search for that letter. I've posted it up there. Essentially what she said is, well, this is something that is handled through the courts and I can't advise on any specific situation. So again, it's very unusual for someone to come in to see us who has $1 million worth of jewelry. And even your wedding ring, which obviously has great sentimental value and which you paid full retail for, in a liquidation scenario, it's worth a lot less anyways.
It's not worth much to anybody except for you and your spouse.
Yeah, and you sell it to a jeweler, they're melting it down, and it's
right.
worth whatever the gold content is. So our advice then is, when you come in to see us, well, tell us what you got. We're going to ask you that anyways. What, jewelry do you have? And in most cases, it's not going to be a significant enough number to worry about.
Yeah, the goal of this part of the conversation isn't to scare people. I don't want you to think that we're going to start cleaning out your jewelry boxes. It's just to make you aware that the law was changed, and unfortunately, the changes weren't drafted very well. There's a lot of ambiguity in this new law, and we're going to talk about some more of them right now, I'm sure. Well,
okay, so let's hit really quickly two other ones. It used to be household furniture, utensils, equipment, food, and fuel, which is exempt up to $11,300. That limit's been up to $13,150, but now it includes household furnishings and appliances. I guess that's really not a whole lot different than what the first rule was.
Yeah, my concern is that, so again, things like your children's toys. Is that an appliance or furnishings? The sports equipment, if it didn't fall under clothing, so maybe you've got a mountain bike or something that you use for keeping yourself fit. I don't think that's furnishing or an appliance. I'm not sure where things like that fall. Now, somebody could be saying, well, if you're falling on hard times or you've got a debt and somebody sued you, maybe they should have the right to take those things. I'm not sure I agree with that. If you take away an individual's minimum requirements to live, and we'll argue over what that is, it's less likely that they're going to comply with the law. And I don't know, that's not the kind of caring society that we all think we live in.
Yeah, who are you serving by doing that? And I think, again, the law says what it says, but in real life, when I look at your used hockey equipment, I'm saying to myself, you know what? It's not worth it. It's certainly not worth it for me to take it. So our advice is be upfront with us, but let's work out a way to make this all work out.
Yeah.
So tell me about tools of the trade then. What does that mean? What's the deal there?
So tools of the trade are things, assets, stuff that you own that you actively use to generate income. So I'll give you a great example. Let's say I'm a courier. I pick up and deliver packages for people. Well, a tool of the trade for me would be my car, probably my cell phone, my computer. Now, let's say instead of being a courier, I work down at the auto parts plant. I make widgets. I use my car to go back and forth to work. Well, if I don't have my car, I can't get to work, but it's not a tool of the trade. I don't use it at work. I use it to get to work, and that's a pretty big distinction.
Yeah, so a tool of the trade is something you are using to earn an income while you're earning that income.
Correct.
So if I'm an Uber driver.
Yeah, if you're an Uber driver, I'd argue that your cell phone, your computer, and your car presumably could be a tool of the trade.
Now, presumably, I've got the exemption of the car anyway, so it may not be an issue. So, okay.
Well, you notice this is a higher exemption, so you might want to use this.
So it would depend. Yeah. I guess if I've got a $10,000 car, and again, we are merely speculating here. There has never been, to my knowledge, a court case in Ontario under the new rules with an Uber driver's car. It has never happened, and it will be a year or two or three before something like that could even appear in court. So our job is to, we've done a lot of research on this. We've spoken to many lawyers and revised our opinions as we learned more and talked to more people. This is what we think. Right now we're in February of 2016 as we record this. This is what we think the law is today, but we want you to come in and talk to us about your specific situation so we can give you the most up-to-date guidance. Now, there was one more change in the rules that was probably the biggest change, so we're kind of burying the lead here talking about it last, but that is the principal residence. And I don't want to call it the principal residence exemption because I don't think that's the right way to say it. But in Alberta, for example, they have what's called a homestead exemption. And so if you go bankrupt or have any of these other legal situations that we talked about, your homestead, which would be your house and some land associated with it, is exempt up to, I believe it's $40,000,
right.
But don't quote me on that number. In Ontario, we've never had anything like that. So if you went bankrupt and you had a house that had $1 of equity, well, you had to give us the dollar or give us the house. That was the rule. Don't think we ever took a dollar from someone for their house, but legally that's what the rules said. So what does the new rule say?
So the new rule says that a creditor cannot seize or force the sale of a property that has $10,000 or less of equity in it. So when the law was first announced in December, people read that and said, great, there's a $10,000 exemption. The first $10,000 in equity is protected in Ontario now. That's not the case. At least that's not the way we see it or the lawyers that we've talked to. What it says is if you have $10,000 or less of equity in your house, then a creditor or a bankruptcy trustee can't force you to sell the house. So they can't go after that less than $10,000 in equity. If you have $10,001 of equity, then the creditor can force the sale of the house or the trustee has to deal with it if you file bankruptcy.
So why did they do it that way? And I know I'm asking you to explain the government, so this is going to be impossible for you to do.
I'll try to keep it polite.
But I'll ask anyway. So you're describing two different methodologies here. If I own a car, a motor vehicle, you said that if it's worth, a little more than $6,600, I get to keep the first $6,600.
Right.
But in the case of a house, if it's worth $1 more than $10,000, I don't get to keep the first $10,000. The whole thing is at risk. So, what's the deal there?
Yeah, I don't quite get why the government worded it this way. It was done deliberately. They could have simply copied the homesteader law from Alberta or some other places across the country. The only thing I can consider is that they wanted to either protect very low-income Canadians who got into a home that's not worth a lot of money, or new home buyers. So they haven't built up any equity in their house yet because it took them a lot of effort and time to get that down payment to buy the house. If it was immediately taken from them, then who knows how long it would take them to do it again. Those are the only two explanations that I could come up with. I don't like either of them.
Yeah, and it could also be that they didn't think it through completely. But
that's the real answer.
Yeah, I mean, it would sound like, yes, it is protection for the person who is just starting out, who's got very little equity. Do we really want to be having a creditor faced with somebody who has a couple of $1,000 worth of equity in their house, going to court, going through the whole foreclosure proceedings, kicking them out, for a couple of grand, really? I mean, it almost doesn't make any sense. So now, in the past, if someone came in to see us and they had equity in their house, our natural thought would be, okay, you don't want to go bankrupt because that puts it at risk. We would suggest
file a proposal.
File a consumer proposal. And in a consumer proposal, your assets are protected. You don't lose them. Now, obviously, you're making payments in the proposal sufficient that the creditors agree to it.
Yep.
So with this new rule, does that change the world of proposals at all?
I don't think it's changed much of anything. For the folks that had less than $10,000 worth of equity in their home probably wouldn't be using their house as the only reason they were filing a proposal. So just briefly, folks, the concept behind a proposal is you offer to repay a portion of your debt. There are two caveats. It has to be more than your creditors would be entitled to in a bankruptcy, and it's got to be enough that the creditors will agree to the offer. Well, so in a bankruptcy, if you had less than $10,000 worth of equity in the house, it's questionable whether or not the trustee would force the sale of the house. They might have you simply pay that equity over 3 or 4 years. Well, so that hasn't changed the calculation that we're going through now to determine how much a proposal would be worth.
Yeah, and you're right. A proposal is an alternative to bankruptcy. In a bankruptcy, I am going to lose a portion of my income if it's over the limit. Yep. I'm going to lose assets that aren't on this list of being exempt. So most people who would have a house with $20,000 or $30,000 in equity probably earn more than the minimum threshold set by the government. So they are going the proposal route because of both their assets and their surplus income. So do you find it changes the math a tiny little bit, a huge amount, not really much?
There's a very small segment of the people that we see that this has had an impact on. The folks so their equity in their house is $9,500. Well, so now in a bankruptcy, that's not something we can go after. So conceivably, it reduces the amount they'd have to offer in a proposal. But there aren't that many people that fall into that category. You either have equity in your house or you don't, unless you've only just bought it. And again, so now we're back to the example of somebody's only had it for a year or two.
Well, in a lot of cases, it's the creditors, the people you owe money to, who are driving what you've got to pay in a proposal. So,
Right.
so I might have, $5,000 in equity in my house, and I might have $5,000 or $10,000 worth of potential surplus income, but I may not be able to offer a $15,000 proposal.
Right.
That particular bank who we're dealing with, who shall remain nameless, because we don't want to pick on any particular banks, they might say, no, our minimum in your case would be $20,000 or $25,000.
Right.
So again, I guess as we wrap up this segment, the message is there's a whole bunch of new rules. It's a bit of a moving target. Come in and see us. Yep. We'll walk you through in your specific situation. Don't try to read this on the internet and figure out how it would apply to you. I don't believe in doing heart surgery over the internet either. Come in and see us. Won't cost you anything. We'll walk you through it.
Yep.
Great. Thanks for being with me, Ted. We're going to take a quick break and be back with the next segment. You're listening to Debt Free in 30.
You're listening to Debt Free in 30. Here's your host, Doug Hoyes.
Welcome back. It's time for the 30-second recap of what we discussed today. On today's show, Ted Michaelis and I discussed the changes to the Ontario Execution Act that prevents creditors or a bankruptcy trustee from seizing certain assets. That's the 30-second recap of what we discussed today. As I said on the show, the rules we discussed are new, so no one knows for sure exactly how they'll be viewed by the courts, so it's likely some of these rules will evolve over time. If you're listening to this show on the radio or on our podcast when it was released in February 2016, the information is current. But if you're listening to this podcast many months after February 2016, you should definitely consult a licensed insolvency trustee or a lawyer before making any decisions if you think any of these rules may impact your situation. That's our show for today. Full show notes are available on our website, including links to everything we discussed today. So please go to our website at hoyes.com, that's HOYES.com, for more information. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.
Thanks for listening. That was Debt Free in 30.